Good day, class. Welcome to sales. So let's go to chapter 1 and let's proceed. Let's go to the statutory definition of a contract of sale. So sales is found, the law on sales is found in the Civil Code of the Philippines. Okay, so according to Article 1458 of the Civil Code, by the contract of sale, one of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other to pay therefor a price certain in money or its equivalent. A contract of sale may be absolute or conditional. All right, so let's discuss this by one. This is a very important provision. In my traditional face-to-face classes, I usually ask my students to memorize this provision. So a contract of sale is a contract whereby one of the parties, called the seller or the vendor, obligates himself to deliver something to the other, called the buyer or purchaser or vendee, who binds himself to pay therefor a sum of money or its equivalent, known as the price. So class, we encounter sales all the time. And a contract of sale is an example of a contract. So we remember our obligations and contracts. No? So what are the characteristics of a contract of sale? Number one, it is consensual. It is perfected by mere consent. If there is meeting of the minds between the parties, kung nagkasundo na sila sa price, at saka kung ano yung determinate thing na binibili, there is a contract of sale. Does it have to be written? There are certain examples which need to be written in order for them to be enforceable, but we'll get to that later. All right? But basically, a contract of sale is consensual. It is perfected by mere consent. Hindi kailangan nakasulat yan. Hindi kailangan ng written contract. Kapag pumunta ka sa palengke, pag nagkasundo na kayo ng tindera, hindi mo pwedeng sabihin bigla, teka, wala naman tayong kontrata eh. Meron, alright? Because a contract of sale is perfected by mere consent. Okay, class? So it is also bilateral, meaning both contracting parties are bound to fulfill obligations reciprocally towards each other. So meaning the seller has to deliver and transfer ownership of the thing sold and the buyer to pay the price. Okay, so basically that's a contract of sale. No? So the buyer has to pay the price, the seller has to deliver and transfer ownership of the thing. Number three, it is onerous because the thing sold is conveyed in consideration of the price. Okay? The opposite of onerous is gratuitous. A contract of sale is different from a contract of donation. Sa donation, nagbibigay ka ng gamit out of love or out of, etc. Sa contract of sale, it is onerous. You are selling the thing in exchange of money. Number four, commutative. The thing sold is considered the equivalent of the price. Number five, nominate. It is given a special name or designation under the Civil Code of the Philippines. All right, so the law on sales is it is specifically provided for under the Civil Code. And nakasulat talaga doon the law on sales. No? Number six, it is principal. It does not depend for its existence and validity upon another contract. So meaning, a contract of sale can stand on its own. All right? Anong opposite ng principal? Accessory. No? Anong example ng accessory contract? A contract of mortgage. Hindi pwedeng contract of mortgage lang. Ano ang principal contract niya? Hindi contract of loan. No? Hindi ka pwede magsangla kung wala ka namang utang. That's just weird, no? In Philippine parlance, pag sinasabi natin magsasangla tayo, ibig sabihin, umuutang ka rin. Hindi ka magsasangla ng basta magsasangla lang. Nagsasangla ka because because you entered into a contract of loan. Pero pwede ka bang umutang ng walang sangla? Yes, pwede. You can enter into a contract of loan without entering into a contract of mortgage. But you cannot enter into a contract of mortgage by itself. You also need to get into a contract of loan. All right? So a contract of sale is a principal contract. What are the essential requisites of a contract of sale? If you will notice, class, no, it's similar to the essential requisites of a contract. Okay? Because a contract of sale is also a contract. Number one, consent or meeting of the minds. Consent on the part of the seller or the vendor to transfer and deliver, and on the part of the buyer to pay. There should be an offer and acceptance of the offer. Okay? So imagine yourself in a bargain, no? Let's say pumunta kayo sa sa Tiangge, sa ganyan. All right? Tinatanong mo yung yung nagbebenta kung magkano yung let's say barbecue. All right? Ang sabi nung nagbebenta, 10 pesos. Ibig sabihin ba may contract of sale na ba doon? Wala pa. Because there's no meeting of the minds, no? All right? Kumbaga wala pang acceptance ng offer. Hindi naman kailangan sabihin na, yes, binibili ko to. It can be done silently. Yung meeting of the minds, it does not have to be expressly given. No, it can be manifested through the actions of the parties. All right. Number two, object or subject matter. The determinate thing, which is the object of the contract. The thing must be determinate. We remember what determinate is, class, no? Or at least capable of being made determinate, because if the seller and the buyer differ in regard to the thing sold, there is no meeting of the minds. The subject matter may be real or personal property. So class, marami tayong concepts sa obliquan na dapat tandaan natin until now. Especially dun sa mga kukuha ng CPA board exams. Alright? Number three, cost or consideration. The price certain in money or its equivalent. As to the seller, the cost is the buyer's promise to pay the price. Kung bakit nagbebenta yung seller, ito ay dahil dun sa promise ng buyer na bayaran siya. As to the buyer, the cost is the seller's promise to deliver the thing sold. So parang baliktaran, no? Yung buyer at saka yung seller. So two kinds of contract of sale. Number one, absolute. It's not subject to any condition whatsoever, and where title or ownership passes to the buyer upon delivery of the thing sold. So class, mapansin nyo dito, no? Ownership passes to the buyer upon delivery. Alright? Importante ang delivery ng thing na binebenta. Okay? We will discuss about this more later. Number two, conditional. Subject to certain conditions, usually the full payment of the purchase price. In this, the delivery of the thing sold does not transfer ownership until the conditions are fulfilled. Ito kapag pinag-usapan ng mga parties, no, na teka, hindi mo na lilipat sa iyo yung ownership kapag hindi ka pa fully paid, kapag hindi ka pa fully nagbabayad. But as a general rule, right, ownership passes to the buyer upon delivery of the thing sold. Article 1459. Okay? The thing must be licit, and the vendor must have a right to transfer the ownership thereof at the time it is delivered. All right? It is a one-sentence provision, but let's discuss this in detail. So, ano bang sabihin ng licit, no? The subject matter must be licit or lawful. Ibig sabihin, dapat legal yung binebenta mo. Dapat hindi siya bawal. Can you sell illegal drugs? Hindi pwede. Paano let's say bumili ka ng illegal drugs, no? Tapos ngayon parang hindi dineliver sa iyo. Pwede ka ba pumunta sa court, no? Para kasuhan yung tao, para utusan siya ng court na i-deliver yung illegal drugs sa iyo? Hindi pwede 'yun. Mahuhuli ka pa or worse, no? Must not be contrary to law, morals, good customs, public order, or public policy, and it should not be impossible. Hindi mo pwede ibenta sa isang tao yung moon. Hindi mo pwede ibenta yung sun because those are, impossible. It must be within the commerce of men. Must not include those under public ownership, such as public bridges, parks, and those common to everybody like air, sunshine, etc. O class, pinaalala ko, no? This is an actual case. Alright? Maraming mga sindikato na nagbebenta ng mga lupa na sinasabi nila ang may-ari nun na isang family lang. So what they do is, no? What they do is, kunwari binebenta nila yung property na yan. Okay, actually, ang defense nila, hindi nila binebenta. Parang ang sinasabi nila, parang nangongolekta sila ng bayad for, for prayer fees, etc., etc. Tapos, papatirahin nila yung tao doon. No? So yung tao nagkakaroon ng illusion na may karapatan dun sa property na yun. Pero wala, no? That's a void contract. Okay? Tapos be wary class, no? Baka meron lumapit sa inyo, baka ibenta yung public park like Perez Park in Lucena or etc. Pag ganun, kalokohan yun, scam yun. Okay? Madaming scam ngayon. So mag-iingat kayo. You have to, some of you will be CPAs, some of you will be lawyers, some of you will be professionals, most of you will be college graduates. So, kayong hinga ng advice ng mga families ninyo. Okay, so you have to be wary. Okay? You have to be careful in dealing with people. Kasi maraming scam ngayon. May mga nagbebenta ng Perez Park, may nagbebenta ng kung ano-ano. Kunwari, just to get your money, your hard-earned money. Only rights which are not intransmissible or personal may be the object of sale, like right of use of rock, etc. Okay? So what are example of intransmissible rights? So class yung mga rights pwede to ibenta, no? Under the law. But meron mga tinatawag na intransmissible rights. These are the right to vote, marital and parental rights. All right? Hindi mo pwede yung karapatan mo na bumoto, no? Because it's your constitutional right to vote, assuming you have all the qualifications to vote, no? Hindi mo pwede sabihin na bayaran mo na lang ako, ikaw bumoto para sa akin. Bawal 'yon. That's intransmissible. Okay? Examples of personal rights are the right to be a partner in the partnership. Pero mag-pause tayo dito. Bakit ito yung example sa book? You already you already took up partnership law, no? Pwede ba 'to? Pwede bang mangyari na imbes na ikaw na lang ang maging partner sa partnership, kukuha ka ng iba, ibebenta mo yung rights mo? Pwede ba 'yon? Na yung taong yun na lang magiging partner? Bawal 'yon, all right? But pwede mo ibenta yung right mo to receive the share in the profits. Up to that extent, pwede 'yon. All right? The right to act as an agent of another, and the right of the bailee to use the thing loaned in a contract of comodato. Okay, so ito pa yung mga hindi pwede, no? Ito pa yung intransmissible rights. What are the kinds of illicit things? Number 1, illicit per se, by its nature, or per accidents. The law makes it illegal, no? Ano example ng mga illicit per se? Decayed food unfit for human consumption. Bawal ka magbenta ng pagkain na expired, no? Unless of course gagawin mong kakaning baboy yan. That's a different matter. Pero let's say restaurant, no? Tapos ang binebenta sa iyo, or let's say nasa tindahan ka, Ang binibenta sa'yo para kainin mo, bulok. Bawal yon. Alright? Examples of things which are illicit per accidents. Illegal drugs. So, right of the vendor to transfer ownership. General rule, you can only sell what you own. Alright? Hindi ka pwede magbenta ng gamit ng ibang tao. So what is the exception? This can be valid if the right to transfer ownership exists at the time of delivery. It is not required that the vendor has the right to transfer ownership at the time of perfection of the contract. So we will discuss the stages of a contract of sale, no? So itong at the time of perfection, hindi naman kailangan, no? Hindi naman kailangan na hawak na ng vendor yung thing na ibebenta niya. Okay? The sale is valid as long as the seller has the right to sell the thing at the time the ownership needs to pass. So class, this is a bit tricky, no? It's a bit tricky to understand this. Hindi ka pwede magbenta ng gamit ng ibang tao. Pero pwede ka magbenta ng thing na alam mong mapapasayo, na alam mong at the time of delivery, you can perform your obligation. Pwede yon. Okay? Pero kung alam mong hindi mo talaga makukuha yan, kung alam mong hindi ka talaga makapag-deliver, hindi pwede yon. Okay? Future goods may be the subject matter of sale. Example, sale of crops yet to be harvested, the sale of chicks yet to hatch, the sale of property yet to be adjudicated by a court. So class, no, let's say farmer ka, tapos gusto mo na ibenta yung mga bigas mo, pero kakatanim mo pa lang. So ang understanding doon, you are selling future goods, and that is perfectly valid. Alright? So pwede naman yon. The subject matter must be determinate. So let's remember what determinate is. Okay? So we've been learning determinate since oblique 1. A thing is determinate when it is particularly designated or physically segregated from all others of the same class. So anong example yan, no? So this ball pen that I'm holding right now, the shirt that I am wearing right now, are those determinate? Yes, they are, because through my intention, through my manifestation, I made them physically segregated or designated from all others of the same class. Itong ballpen na to class, maraming ganito. No? Pero by my manifestation, sabi ko, I'm selling you the ballpen that I'm holding right now. So this is now determinate. A determinate thing is identified by its individuality. For example, the watch I am wearing, the car with plate number AAA555. It is sufficient if the thing is determinable or capable of being made determinate without the necessity of a new or further agreement between the parties. If there are further agreements needed as to ascertain the identity, quantity, or quality of the object, then the sale is void because there's no meeting of the minds. All right? Kung ano yung i-deliver. Article 1461. Things having a potential existence may be the object of the contract of sale. The efficacy of the sale of a mere hope or expectancy is deemed subject to the condition that the thing will come into existence. The sale of a vain hope or expectancy is void. Now, let's discuss this. No? This is also a very important provision. So sale of things having potential existence, a future thing not existing at the time of perfection of the contract may be the object of sale, provided it has a potential or possible existence. So pwede yan class. No? Ang example niyan, let's say meron kang palayan. Tapos binebenta mo na yung magiging bigas na aanihin mo, or bigas or palay, whatever, no? So yun, pwede yun. Kasi alam mo naman tutubo siya. Magiging void yan class kung wala ka naman palayan, no? Kung let's say niloloko mo lang yung tao. then that is void. Alright? Pero kung meron kang palayan, alam mo naman na meron kang aanihin, then that is perfectly valid. It is reasonably certain to come into existence. The vine is expected to produce, the grain a field may grow, and the milk a cow may yield. So sale of hope or expectancy. This is subject to the condition that the thing contemplated or expected will come into existence. A sale refers to an expected thing, not yet in existence, not to the hope or expectancy. It is void if the hope or expectancy is vain, such as sale of falsified lotto tickets. Okay? Or let's say nagbenta ka ng ticket, no, na raffle ticket na expired, no? That sale is void because parang wala kang chance na manalo doon. All right? Okay? A sale of sweepstakes ticket is valid because the object of the contract is the hope itself. It is not subject to the condition that the hope will be fulfilled. All right? So pagbenta ng lotto ticket class, it is valid because what are you buying there? Yes, you're buying the lotto ticket, but you're buying the chance of winning the jackpot prize or consolation prize or whatever. Pero yung pag nagbenta ka ng fake na lotto ticket or pag nagbenta ka ng expired na raffle ticket, that sale is void. All right? Kasi walang chance manalo yon, class. Sa totoo lang, class, no, kung tumaya ka sa lotto, may nananalo sa lotto syempre, no? Pero it's very hard to win the lottery. May nagsabi sa akin, no, mas mataas yung chance na tamaan ka ng kidlat, no? Habang naglalakad pupunta ng lotto ticket kaysa manalo sa lotto. But anyway, no, I'm not preventing you from buying sweepstakes tickets. But anyway, no, the sale of sweepstakes ticket is valid, right? Because what you're buying is the hope. And meron naman kasing hope. Okay? Sale of future goods. The goods to be manufactured, raised, or acquired. It is valid. It is an executory contract that will be fulfilled by delivery of the goods. Alright? Anong sabihin ng executory contract? Gagawin pa lang. Alright? Yun ang sabihin ng executory contract. Wala pang performance dyan. Gagawin pa lang. So that's what you mean by executory. It is different from a contract for a piece of work. We'll get to that later. All right. Article 1463. The sole owner of a thing may sell an undivided interest therein. Oh, this is interesting, class, no? Usually, nag-a-apply ito sa mga manahan ng lupa. No? So I've had students asking me from time to time, no? Let's say may personal family issues sila, ganyan-ganyan. Yung pamilya gusto ibenta yung lupa, yung iba ayaw. So pag-usapan natin yan. So what the seller can sell, no? The sole owner may sell the entire thing. Class, let's use an example. Imagine yourself na kunwari may minana kayo. Knock on wood, no? Kunwari yung mga ascendants nyo, so umalis na, no? So kayo ang napag-iwanan ng property. All right? So let's say nag-iisang anak ka, wala kang kahati. So say napunta ang buong property, can you sell the entire property by yourself? Yes, you can sell the entire property by yourself, walang problema. Kasi nag-iisa ka lang. The whole property is titled under your name. So pwede mo ibenta yan. Number 2, the sole owner may sell only a specific portion thereof. O kung nag-iisa ka lang, pwede mo ibenta kalahati lang ng property or 3/4 lang, 1/4. Yes, pwede. Okay, as long as the thing is capable of being subdivided, pwede. All right? Ito pala, class, no? So yun, pwede yun, no? Sole owner, number 3, sole owner may sell an undivided interest therein. Okay, so medyo may ano dito, may terminology na medyo baka malito yung iba sa atin, no? Undivided interest therein, and such interest may be designated as an aliquot part of the whole, making the buyer and seller co-owners of the thing. Alright? Anong sabihin nito? So class, sige, baguhin natin yung example. Kunwari, 3 kayong magkakapatid. Apat na lang para easy computation. 4 magkakapatid. Alright? So yung minana nyo, edi apat, tig 1/4 kayo. Tig 1/4 kayo magkakapatid. Ang tanong, ikaw ba? Ikaw kasi gusto mo ibenta yung buong property kasi gusto mo ng pera. Yung mga kapatid mo, ayaw nila ibenta. Ang tanong ko, can you sell the property by yourself? Let's say may pumunta sa yung tao, no? Gustong-gusto yung lupa na minana ninyo. Gusto bilhin yung lupa ninyo ng 100 million pesos. Ayaw ng mga kapatid mo, pero ikaw gustong-gusto mo. Can you sell the whole property in behalf, let's say ikaw ang panganay, can you sell the whole property in behalf of your siblings, or your co-heirs or co-owners? The answer is no. Alright? Kailangan lahat ng consent ng mga co-owners mo. So yung pala class, no? So kayong 4 na magkakapatid, you are co-owners of the property. Co-owners kayo. Alright? So kayong lahat, kayo may-ari ng property. Pero hindi pa nahati yan. Okay? Basta let's say kakamatay lang ng ng ascendants nyo. All right? You already own an adequate portion of the estate ng ascendants nyo. So yung iniwan sa inyong lupa, ganyan, co-owners na kayo niyan. Depende lang kung paano niyo pag-usapan. Assuming na walang last will and testament. Ha? So depende kung anong usapan niyo kung paano hatian. All right? But usually kung 4 kayo magkakapatid, edi you own 1/4 of the properties left by your ascendants. So in class, no, pag gusto niyo ibenta yung kabuuang lupa, dapat lahat sila papayag. Pero ito, paano kung ang gusto mo lang ibenta yung 1/4 share mo? Pwede ba 'yon? The answer is yes. Pwede mo ibenta 'yan. Yung 1/4 share mo. But yung mga co-owners na iba, yung tatlong mga kapatid, they can exercise the right of redemption para bilhin yung share na yon na binenta mo sa ibang tao. Ibig sabihin, pwede nila bilhin sa isang tao na yon yung binenta mo sa kanya. Okay? Alright? But anyway, no, that's too advanced for this class. Mag-focus tayo dito, no? So, the co-owner may sell his share without the consent of the other co-owner. So, malinaw yun, class, no? Kung undivided yung interest, hindi tiyak dun sa property kung alin yung 1/4 mo dyan. Kasi hindi pa kayo nag-subdivide. Okay? So kumbaga, you own, kayong 4 na magkakapatid, you own the whole property. Pero as regards yourself, ikaw, meron ka dong ownership ng 1/4. Yun nga lang, hindi pa tiyak dun kung saan yung 1/4 mo. Alright? So meaning of fungible goods. Goods of which any unit is treated as the equivalent of any other unit. Example, grain, oil, wine, or gasoline. Ito klase yung mga bagay na parang kanin, no? Let's say, rather bigas. Let's say nagbebenta ka ng dinorado rice. No? Let's say bibili ka ng dinorado rice. Yung dinorado rice, nakalagay yan usually sa sako o sa let's say sa palengke, no? Bibili ka lang sa nakalagay yan sa canister, sa lalagyan, naka-display dyan. Alright? Tapos ang binibili mo, 1 kilo lang. So ang gagawin dyan, kukuha doon, titimbangin. So yan ang fungible goods. So mga palay, bigas, gasoline, sabihin nito, yung 1 kilo na binili mo ngayon, kapareho lang yan ng 1 kilo din na bibili ng ibang tao. Yan ang fungible goods. Alright? Yung na-measure, yung nagaganyan, yung mga palay, yung mga grains, mga ganyan. No? Alright? Yun ang meaning ng fungible goods. The buyer becomes co-owner with the seller of the whole mass in the proportion in which the definite share bought bears to the mass. Example, 250 kavans out of 1,000 kavans. That's 1/4 of the contents. All right? Assuming na hindi pa to let's say tinuro mo dun sa sa tindera na ale pabili pong parang 1 kilo, no? So kumbaga class, yung the moment na sinabi mo yon, tapos pumayag siya, no? Let's say may perfected consent na kayo, tapos hindi pa na deliver sa yung bigas. Alright? Kumbaga, you're a co-owner. You're a co-owner of 1 kilo kung tapos kung ilan man yun. Let's say ang laman ng canister ay sabihin natin 25 kilos. No? So you're a co-owner of 1/25 of that sack of rice, of that canister. Kasi hindi pa natatanggal yung share mo eh. Alright? So yun, no? So yun ang fungible goods. Article 1465. Things subject or resolutory condition may be the object of the contract of sale. So let's remember resolutory condition. No? So galing to sa oblicon. Alright? A resolutory condition is an uncertain event, the happening of which extinguishes the obligation. Ano opposite ng resolutory condition? Suspensive condition. Yung mga BSA students, you have to know this, no? O kahit hindi BSA, you have to know this pa rin. The happening of the resolutory condition will also extinguish the right acquired in a sale. For example, sale of land to a third party under pacto derecho sale. Ano ang pacto derecho sale? Sale with the right to repurchase. No? Example nito, S sold a parcel of land to B subject to the condition that S can repurchase the property within 2 years from the date of sale. If B sells the parcel of land before the lapse of 2 years to a third person, S will have a better right to the title. So bakit ba ito ginagawa, class? No? Bakit ginagawa itong sale with the right to repurchase? Ginagawa ito kasi minsan yung tao, wala talaga siyang intention na ibenta yung property niya. Anong gusto lang niya gawin? Ang gusto lang niya gawin, gusto niya umutang, kunwari, no? Pero dapat 'di ba real estate mortgage? Pero hindi, para mas sigurado yung para mas sigurado yung buyer o yung nagpautang, no? Para mas sigurado, edi pacto derecho sale na lang, no? So ibebenta ni seller yung property with the right to repurchase. Sabi dito 2 years, no? So ibig sabihin within 2 years, no? Pwedeng bilhin ulit ni seller yung property niya from the buyer. Okay? So that's a sale with the right to repurchase. Isa pang example, exercise by the mortgagor of the right of redemption. For failure of S to pay his debt, his land was foreclosed and was sold to B, the highest bidder. The mortgagor may redeem the property at any time within 1 year from the date of sale. So class, baka yung iba sa inyo magtatrabaho sa bank in the future. Alright? So paano kung umutang yung tao sa bangko? Tapos as collateral, sinangla niya yung bahay niya. Alright? Hindi siya nakapagbayad. So anong ginawa ng bangko? Foreclose. Okay? Tapos naka-public auction yung property niya. Ngayon, merong highest bidder na bumili ng property. Pag ganun ba, automatic ba na siya na agad ang may-ari nun? The answer is no. Alright? Because under the law class, pag na-foreclose na yung property, meron ng highest bidder. Alright? The mortgagor is granted by the law 1 year. Provided na hindi corporation na. Pag corporation ang umutang, pag na-register na yung sale, wala na. Pero pag individual na tao, alright, meron siyang right of redemption, no? Meron siyang right of redemption of 1 year from the date of auction sale. Okay? What is the difference between the sale and an agency to sell? Number 1. In the contract of sale, It is a contract where one of the parties delivers to another a determinate thing in exchange for a sum certain in money. What is a contract of agency? A person binds himself to render some service or to do something in representation or on behalf of another with the consent or authority of the latter. So class, no? For example, nagbebenta ng property yung parents mo. Yung parents mo, let's say, busy sila masyado. Anong pwede nila gawin? Pwede ka nila bigyan ng authority na ibenta yung property nila. Anong ibibigay sa'yo? Anong proof ng authority na yun? Pwedeng SPS, a special power of attorney. No? Lalo na pag property ang pinag-uusapan, it has to be notarized. Alright? The buyer, in the contract of sale, the buyer receives the goods as owner. Sa contract of agency, the agent receives the goods as the goods of the principal who retains his ownership over them. Alright? So yung agent, tinatanggap yung goods not for his own consumption or for his own use, pero para ibenta niya. Ganyan, no? Ang may-ari pa rin ng goods na yon, yung principal pa rin. Anyway, no, we will also be discussing the law on agency right after the law on sales. In the contract of sale, the buyer has to pay the price. In the contract of agency, the agent has to account for the proceeds of the sale he may make on the principal's behalf. So class, grabe yung trust sa isang agent, no? The contract of sale, the buyer cannot return the object sold as a general rule. Okay? Contract of agency, the agent can return the object in case he is unable to sell the same to a third person. In the contract of sale, the seller warrants the thing sold. All right? In the contract of agency, the agent makes no warranty as long as he acts within his authority and in the name of the seller. Contract of sale, the buyer can deal with the thing as he pleases. In the contract of agency, the agent must act and is bound according to the instructions of his principal. So, the contract of sale. This is a difference between sale and a contract for a piece of work. All right. What is a contract for? We already know what a contract of sale is. Now, what is a contract for a piece of work? For example, class, no, let's say you're an extraordinary person. Let's say ang size ng paa mo ay 20. Kumari lang, no? Ang size ng paa mo ay 20. Pag pumunta ka ba sa SM, meron ka ba makikita na size 20? US size, hindi European size. Alright, ako may shoe size is only size 10, no? Size 20, sobrang bihira yan. So, ano gagawin mo pag ganun? Forever ka bang walang sapatos? Hindi. Ang gagawin mo, pupunta ka sa sapatero, no? Magpapagawa ka ng sarili mo sapatos. Alright? Pag ganyan class, that is already a contract for a piece of work. That is not a contract of sale. Okay? Paano class kapag ang size ng paa mo ay 13, kunwari, no? Pumunta ka sa Nike. Ganyan, no? Tapos tinanong mo yung sales lady, miss, may size 13 ba kayo? So ang ginawa nung babae, nagulat, no? So ang ginawa niya, naghalungkat siya. Pumunta pa siya sa factory, ganyan. May nakita siya, size 13. Tapos pinigay na sa'yo. Is that a contract of sale? Tapos binili mo, ganyan. Is that a contract of sale or a contract for a piece of work? That is still a contract of sale. Okay? Okay, a contract of sale, a contract where one of the parties delivers to another a determinate thing in exchange for a sum certain in money. Contract for a piece of work. The contractor binds himself to execute a piece of work for the employer in consideration of a certain price or compensation. Alright? So kumbaga may special ano sa'yo. May special consideration. Okay? In the contract of sale, the thing transferred is one which would have existed and been the subject of sale to some other person even if the order had not been given. So example nito yung size 13 na sapatos, no? So ito, kumbaga matagal na yan meron dyan, no? Na kung hindi sa'yo binenta, ibebenta yan sa iba. So kahit malaki yan, edi ano, edi for sure marami din namang mga size 13, mga ganyan. So that is a contract of sale. A contract for a piece of work, it is not in existence. It never would have existed if it were not for the order of the party desiring to acquire it. Maybe you're familiar, class, with ano, no, with the old generation Chinese na merong lotus feet, no? Ang size naman ng paa nila hindi malaki, kabaliktaran, no? Ang mga paa nila usually mga ano lang daw, mga parang 3 inches lang or 4 inches. I might be mistaken, pero maliit lang, no? So pag ganun, class, no? Usually ang mga ganyan yung mga old Chinese, but it's the old generation already, no? Marami sa kanila, nag-pass away na kasi matagal na yun. Hindi na siya pinapractice ng Chinese ngayon. Pero may mga buhay pa na Chinese Filipinas, no? And this is for the women. Marami mga Chinese Filipinas na ginawa yon, pero matanda na sila. So pag gano'n, magpapagawa sila ng ano, hindi sila makakita niyan sa SM or whatever. Palagi ko example yung SM. So anyway, hindi yan basta-basta makikita kung saan. So yan, pinapagawa, pinapasadya. So that is a contract for a piece of work. So in a contract of sale, so this is important, class, no? In a contract of sale, the risk of loss is borne by the buyer. So this is after perfection but before delivery. No? Pag ganyan, the risk of loss is borne by the buyer. Let's say, nag-agree na yung buyer at saka seller. For example, bumili ka ng sapatos, nabalik tayo sa sapatos. Pumunta ka sa store, tapos may nagustuhan kang sapatos. No? So nagbayad ka na and stuff. Tapos ida-deliver sa'yo kinabukasan. Kunwari, nagkataon, yung shoe store nasunog. So syempre, nasunog din yung sapatos mo. Alright? Under the law, makakuha ka ba ng refund? Kasi wala yung sapatos mo, nasunog nasunog yung store. Who bears the risk of loss? It is you, the buyer. Okay? So kung nagbayad ka na, wala na yun. You bear the risk of loss under the law. Okay? Pero punta tayo sa contract for a piece of work. The risk of loss is borne by the worker or contractor. Same example. Pero ito sa sapatero, yung gumagawa ng sapatos. Okay? So anong nangyari, nagpagawa ka ng sapatos, i-deliver sana kinabukasan. Nasunog yung nasunog yung mga sapatos ng sapatero, nasunog yung shop niya. Who bears the risk of loss, class? Under the law, the one who bears the risk of loss is the worker or the contractor. Okay? So kahit nasunugan siya or kahit ninakawan yung shop niya, kailangan gawin pa rin niya yung sapatos para sa'yo. Okay? So, yan ang malaking pagkakaiba ng contract of sale at saka contract for a piece of work. Alright? Ito pang isa na importante. No? A contract of sale is within the statute of frauds. If the price of the personal property is not less than 500 pesos, it must be in writing. Otherwise, the sale is unenforceable. O class, nag-obligo na tayo. So we should remember what enforceable is. Ano ibig sabihin ng enforceable in the first place? Ibig sabihin ng enforceable, pag may isang party na hindi tinupad yung yung obligation niya, pwede mo kasuhan, pwede mo dalhin sa korte. That is enforceable. Okay? Paano pag unenforceable? Pag unenforceable, class, hindi ka papansinin siya ng court, no? Wala kasi hindi nakasulat eh. Okay, pag nasa statute of frauds, class, dapat nakasulat yan for it to be enforceable. Pag hindi nakasulat, it's unenforceable. Example, ito, if the price of personal property is not less than 500 pesos, it must be in writing. So, sabihin, pag ang price ng personal property is 500 pesos and above, it should be in writing. Okay? Anong example? Kotse. Let's say nag-usap kayo ng mga kaibigan mo, pare, bibili ko yung kotse mo. Sabi nung isa, sige, verbal lang. Tapos kinabukasan, no? Hindi parang gusto mo siya bayaran. Kasi sinasabi niya, pare, wala naman tayong kontrata. Pwede mo ba siya kasuhan? Let's say ang presyo pala is 500,000 pesos. Pwede mo ba siya kasuhan? The answer is no. Kasi verbal lang eh. Alright. Pero paano kung nakasulat? Let's say meron kayong memorandum of agreement na magbebentahan kayo ng kotse o kaya deed of sale. Pwede ba siya kasuhan? Yes, pwede na. Pag ayaw na ibenta yung kotse niya, pwede na yun. Okay? Because it's in writing. Hindi naman kailangan na notarized siya or what. Okay? Paano class, no? Maging advanced tayo ng konti. Paano class, let's say, dun sa example ng kotse. Alright? Sabi mo sa kaibigan mo, pare, itong 500,000. Bigyan mo na yung kotse sa akin bukas. Bibiling ko na. Tinanggap niya yung pera mo. Pwede ba kinabukasan? Pwede ba niya sabihin, pare, wala tayong sale kasi wala naman tayong pinirmahan. Pwede ba yung class? Pwede bang hindi na ibigay yung kotse sa'yo? Hindi yun pwede. Alright? Bakit hindi siya pwede? Kasi tumanggap na siya ng pera eh. Kumbaga, the contract is not anymore executory. Pero ng partial fulfillment. Ikaw, nagbigay ka na ng pera. Ganon din class kapag yung kotse, binigay na niya sa'yo. Tapos ngayon, ayaw mo ibigay yung pera. Mali yun. Alright? Pag ganon, pwede ka na niya singilin. Okay? So itong statute of frauds, it only applies if the contract is executory. Okay? Kapag yung mga parties, hindi pa nila ginagawa yung obligations nila. If none of the parties, has performed his or her obligation, wala yan, no? Kapag hindi nakasulat, tapos yung price is 500 pesos and above, the contract is unenforceable. Okay? Now let's go to contract for a piece of work. It is not within the statute of frauds. So isabihin class, kahit mas mataas kahit 500 pesos and above, tapos wala kayong written contract, okay lang yan. It's still valid. It's still enforceable. Okay, yun ang pagkakaiba nila, the contract of sale at saka contract for a piece of work. Okay? So example nito, buying a pair, ang contract of sale, buying a pair of shoes of a particular style and size from a manufacturer who sells the same to the general market, even if the manufacturer makes it for the buyer. Ang example ng contract for a piece of work, placing an order for a pair of shoes of a particular shape because the feet are deformed, manufactured specially and not suitable for sale to others. Now, what is the difference between a contract of sale and a contract of barter or exchange? Okay. A contract of sale is a contract where one of the parties delivers to another a determinate thing in exchange for a sum certain in money. All right, so yan palagi ang definition of contract of sale, no? A contract of barter or exchange, one of the parties binds himself to give one thing in consideration of the other's promise to give another thing. Okay, so yun ang contract of barter. Pero class, maraming qualifications yan. Maraming beses na akala mo barter, no? Pero in reality, contract of sale pala yan. We'll be discussing that, no? So how to determine if sale or barter? If the exchange consists partly in money and partly in another thing. Number one, so naka-hierarchy to, no? So number one, manifest intention of the parties is paramount, taking into consideration the contemporaneous and subsequent acts of the parties. So class, kung may exchange kayo, yung book mo para sa ballpen niya, that is a contract of barter. Paano kapag ano? Paano kapag ang usapan, yung book mo para sa ballpen niya at saka 500 pesos cash? So paano yun? Is it a contract of sale or a contract of barter? Lumalabas to sa CPA board exams. I remember in my particular exams sa business law and taxation, lumabas yun. Alright? So number one, manifest intention of the parties. So kumbaga, kahit mas malaki yung value ng thing kesa dun sa cash, pag ang intention ng parties ay contract of sale yan. So you have to be careful with trick questions like A and B entered into a contract of sale whereby A delivered his book in exchange for B's ball pen plus 500 pesos cash. Is that a contract of sale or a contract of barter? That is a contract of sale. Okay? Bakit? Kasi unang-una pa lang sinabi, A and B entered into a contract of sale. So yun pa lang. That's your hint. Contract of sale na yan. Okay? Number two, if the intention cannot be ascertained, for example, sa exam, sinabi lang, A and B entered into a contract whereby A delivered to B a book in exchange for B's ball pen plus 500 pesos cash. So, dyan, maging depende, no? It is only a barter if the value of the thing given as a part of the consideration exceeds the amount of the money or its equivalent. Let's say ang ballpen na in exchange ay ano lang, yung panda, no? Yung panda ballpen, mura lang yun. During my time, it was only 5 pesos when I was elementary school. Ewan ko lang ngayon, no? Magkano yun. So yun, definitely mas maliit yung value ng ng panda kaysa dun sa 500 pesos. So yun pa lang, it's a contract of sale already. Kasi mas mataas yung value ng 500 pesos kaysa dun sa ballpen. Paano kung equal sila? Example ng 500 pesos na ballpen, Parker ballpen, ganyan. Paano kung equal sila ng value? Yung 500 pesos cash at saka 500 pesos ballpen. That is a contract of sale. Okay? Kasi sinasabi sa batas, it is only a barter if the value of the thing given as a part of the consideration exceeds the amount of money or its equivalent. Okay? Kasi paano kapag ang ballpen na binigay pala ay Mont Blanc, no? Mahal 'yon. It's definitely more than 500 pesos. So pag ganyan, it's a contract of barter. All right? But class, always remember yung number one. Okay? The manifest intention of the parties is paramount. There is no sale if the price is not certain or ascertainable. There can be no sale without a price. Okay? Because the price must be certain or capable of being ascertained. Hindi ka pwede magbenta ng bagay na walang presyo, class. No? Hindi mo pwede, bilhin mo na tong cellphone ko. Tapos nung sinisingil, tapos pumayag ka, no? Sige, bibiling ko yan. Tapos sinabi sa'yo, kasi tumawa siya sa oo mo, no? Ang sinabi niya sa'yo, ang cellphone ko 100,000 pesos. Tapos yung pala, Oppo lang. No? Pag ganyan ba, class, pwede ka ba niya kasuhan? Sabi niya, umuo ka sa akin eh. Hindi ka niya pwede kasuhan, class. Alright? There was no meeting of the minds as regards both the price and the determinate thing. As regards to the determinate thing, sige, meron yung Oppo, yung cellphone na hawak niya. No? Yung pala, napakamahal. No? 100,000 pesos. So there's no meeting of the minds. There is no sale. So what are the cases when the price is considered certain? If the parties have fixed or agreed upon a definite amount, if it is with reference to another thing certain, this only applies when no specific amount has been stipulated by the parties. Kung may pinag-usapang presyo yung parties, yun ang susundin. Alright? If the determination of the price is left to the judgment of a specified person or persons, this only applies when no specific amount has been stipulated by the parties. So klase ito sa number 2. Alright? Paano pagka sinabi, ibebenta ko sa iyo yung lemon ko. Ang presyo nito, kapareho ng presyo sa divisoria. Is there a valid contract, class? Is there a valid sale? Wala, no? Tapos sinabi lang, presyo ng lemon sa divisoria. Class, that's very broad. Ang dami nagbebenta ng lemon sa divisoria. Okay? So yeah, no? So basta it has to be with reference to another thing which is certain. Okay? Tapos pwede ba na third party ang mag-determine ng price? Yes, pwede. Alright? Kung pwede third party ang kung payag ang mga parties, kung payag ang buyer at saka seller, na third party ang mag-determine ng price, yun pwede naman yun. What is the effect of where the price is fixed by the third person designated? So ito yung kapag, let's say yung buyer and seller, hindi sila magkasundo sa price ang sinabi nila, o si C na lang ang mag-set ng price para sa atin. So the general rule is, the price fixed by the third person, specified by the parties, binds the parties. So that is the general rule. Okay? So let's say si A at si B, pumayag sila na si A at si B, pumayag sila na si C ang mag-set ng price nila. Pwede yun. Kung ano yung decision ni C, yun na susundin. Okay? What are the exceptions? Number 1, when the third person acts in bad faith or by mistake, when the third person fixed the price, having in mind a different thing, the court may fix the price thereof. Yung court na magdedetermine ng price, class. Alright? It doesn't mean, class, na kapag hindi kayo magkasundo sa presyo, korte ang magdedetermine ng price nyo. It does not work that way. Okay? Pag hindi kayo magkasundo sa presyo, there is no sale. Remember that. Ha? Kailan lang magkakaroon ng power ang court na mag-determine ng price? Okay? Number 1, kapag yung parties, nag-designate sila ng third person na mag-set ng price pero mali. Hindi mali yung price. So let's say yung third person acted in bad faith or nagkaroon ng mistake, no? Misapprehension of facts, etc. Yung court pwede mag-determine ng price. Number 2, when the third person disregards specific instructions or the procedure laid down by the parties, fixed an arbitrary price, no? So yun, dito hindi pwede. So if the third person designated by the parties refuses or cannot fix it without the fault of either the seller or the buyer, the contract shall become ineffective as if no price had been agreed upon, unless the parties agree upon the price. Okay? Number 2, if the third person was prevented from fixing the price by the fault of either the buyer or the seller, the innocent party may obtain redress against the party in fault. The innocent party may choose between rescission or fulfillment, with damages in either case. If the innocent party chooses fulfillment, the court shall fix the price. Okay? So klase sinasabi dito, pag yung third person, parang kinutsyaba or pinigilan. No? Let's say pinigilan siya ng either ng buyer or ng seller. No? Kung kinutsyaba siya ng buyer, syempre gusto ng buyer yung mababang presyo. Pag kinutsyaba siya ng seller, syempre gusto taasan yung presyo kunwari. Okay? Yung pag ganyan, yung innocent party, he can choose between rescission or fulfillment. What is rescission? We learned this in obligate. Rescission, this is like cancellation. No? Ika-cancel na yung sale. Alright? Kasi merong damage dun sa innocent party. So yun, no? It's either rescission or fulfillment. Kung fulfillment, pwede ituloy yung sale. Okay? Basta may damages to pareho. Ibig sabihin ng damages, babayaran ng pera. Okay? If, so in legal parlance, no? Pag sinabing damages, pera. Okay? If the innocent party chooses fulfillment, the court shall fix the price. What is the effect of gross inadequacy of price? the general rule is it's valid. Paano kung may nagbenta ng murang-mura? It's valid. As a general rule, valid yan. Okay? What is the exception? Inadequacy of price may indicate defect in the consent, such as when fraud, mistake, or undue influence is present. In this case, the contract may be annulled. So class, if you will notice, no, it says here the contract may be annulled, not rescinded. Ano man difference nila, class, no? Pansin nyo, merong annulled, merong rescind. Pero pareho lang, pareho, in a way, no, pareho lang yan na kumbaga parang parang hindi tuloy yung sale. Parang binawi yung sale. Pag annulment, class, no? Let's remember our obligate. Pag annulment ang pinag-uusapan, merong vitiation sa consent. Let's say, tinutukan ka ng baril para ibenta mo yung lupa mo. Anong remedy ng seller doon? Annulment. Ipapa-annul yung sale. Okay, kasi kaya ka lang pumirma, kaya ka lang pumayag, dahil tinutukan ka ng baril. O kaya ka lang pumayag dahil sinasapa ka, sinusunto ka. No? O kaya niloko ka, parang ganyan. Pag sa rescission naman, yung kanina, yung rescinded, merong damage sa'yo. Alright? Yung for example, kapag kinonsyaba yung yung third party, merong damage, merong lesion or damage of more than 1/4 of the price. No? So pag the remedy is rescission. So in this case, no, the contract may be annulled not because of inadequacy of price, but because the consent is vitiated, or when the price is so grossly inadequate or low as to be shocking to the court's conscience that no man in his right mind would accept. All right? Or for example, class, no, nagbenta ka ng property sa bayan ng Lucena. Let's say ang worth ng property is 10 million pesos. Paano kung binenta mo na ng 5 million pesos? Is it valid? Yes, class, it's valid. Alright? Balik tayo sa general rule, no? So, the general rule is the gross inadequacy of price does not mean that it's automatically defective. Okay? Paano kung binenta ng 10,000 pesos o 20,000 pesos? Okay, 100,000 pesos for that matter. Medyo kaduda-duda yun, class. No? Kaduda-duda yun. Kasi 10 million yung worth, tapos ang benta 100,000 pesos lang. So dyan, medyo magkakaroon na ng idea na, teka, baka defective to, baka baka naman, baka may nangyari ditong tutukan or whatever. No? It's shocking to the court's conscience. But as a general rule, it is a valid sale. Kapag sobrang baba ng presyo ng sale, ang general rule, valid pa rin yan. So what is the effect where the price is simulated? It is void. All right? If the parties really intended for a donation, the sale is void but the contract of donation is still valid. Pag-usapan natin to, class, no? Marami nagpapatransfer ng lupa. Alright? Na para matransfer, ang inakala lang nila, dapat deed of sale, no? Pero in truth, excuse me, in truth, wala naman nangyayari na exchange ng pera. Let's say, binibenta mo sa kapatid mo, sa tita mo, sa nanay mo. Alright? Walang exchange ng pera nagaganap, pero natatransfer yung lupa. Pag ganun, kumbaga walang intention yung parties na magbenta talaga. So kumbaga parang donation talaga siya. Pero before kasi class, mas mahal ang donor's taxes. Pero ngayon kasi medyo pantay na yung sale ng property at saka yung medyo pantay na yung taxes na binabayad sa deed of sale at saka yung taxes na binabayad sa deed of donation. Medyo pantay na siya ng konti. Okay? Pero sanay pa rin ang tao talaga na nagkukunwari sila na nagdi-deed of sale sila. Ito pa class, no? Let's say for class purposes, or let's say niloloko ka lang ng kaibigan mo Pare, gawa ka ng dito sale. Ibenta mo sa akin yung bahay mo. Gumawa ka nga, no? Kasi ginawa mo. Kasi para katuwaan lang. Ngayon, sineseryoso niya. Gusto niya kunin yung bahay mo. Is that a valid contract of sale, class? It is not. Alright? Alright? Because the price is simulated. For example, sinabi lang niya, ang presyo kunwari, 1 million pesos, pero lokohan lang to. There's no, the price there is simulated. Okay? So the contract of sale is void. So if the parties really do not intend any sale at all, the contract is void and inexistent. So again, class, the most effective contract is a void contract. It is void from the very beginning. It is incapable of being ratified. No? So it's not capable. It's not capable of ratification. The fixing of price by one of the contracting parties is not allowed. The validity or compliance of the contract cannot be made to depend upon the will of one party. So class, no, hindi pwedeng yung buyer lang ang magsaset ng price, or hindi pwedeng yung seller lang yung magsaset ng price without the other party agreeing. Okay? So hindi pwede yun, ha? Sige, hindi pwede yung sige pare, ibenta mo sa akin yung kotse mo. Kahit sa anong presyong ibigay, kahit sa anong presyong sabihin mo, bibilin ko yan. Natuwa ka sa'yo, no? Kaya para sinabi mo, sige, bibenta ko sa'yo 100 million pesos o 10 million pesos. Pwede ka ba niya kasuhan doon? Hindi pwede. Alright? Kahit ganun yung usapan nyo, hindi pwede. Okay? Ibang usapan syempre kapag sinabi niya, ito 10 million pesos. Tapos sabi mo, sige, bibiling ko. Ito ang bayad ko. Or sinabi, ito yung kotse. Gamitin mo na. Hindi ka nagbabayad ng 10 million pesos. Pwede ka kasuhan doon. Kasi pumayag ka na sa presyo. Alright? So ito, no? However, if the price fixed by one party is accepted by the other, the contract is deemed perfected. So effect of failure to determine the price, number 1. If the contract is executory, class, remember this, no? If the contract is executory, nothing is paid or delivered yet, the contract is without effect if the price cannot be determined. There is no obligation by the vendor to deliver the thing and no obligation by the vendee to pay. Where delivery has been made, if the thing or any part thereof has been delivered, the buyer must pay a reasonable price therefor. The reasonable price or value of the goods is generally the market price at the time and place fixed by the contract or by law for the delivery of the goods. Okay? So class, paano kung wala kayong usapan sa pera, tinanggap mo naman yung delivery ng thing sa'yo. O dapat bayaran mo naman, dapat magbayad ka dyan. Alright? Kasi tinanggap mo yung delivery eh. Pag ganyan, pag wala naman talaga, pag wala naman talaga contract of sale, huwag mo tanggapin yung gamit. Okay? Kasi pag tinanggap mo yan, you will be obliged to pay a reasonable price. Okay? So what are the stages of a contract of sale? Number 1, negotiation. The time the prospective contracting parties indicate interest in the contract until the time the contract is perfected. So dito nag-uusap yung mga parties, no? Yung buyer at saka yung seller. Nag-uusapan yung determinate thing, nag-uusapan yung presyo, etc. Number 2, perfection. This takes place upon the concurrence of the essential elements of the sale. It is also known as the meeting of the minds as to the object and upon the price. Okay? Consummation. When the parties perform their respective undertakings, culminating the extinguishment of the contract. All right? So what stage gives birth to the contract of sale? It is perfection. Right? Nandiyan yung meeting of the minds. So the owner has the right to fix his own price. The owner has the right to quote his own price, reasonable or unreasonable. It is up to the prospective buyer to accept or reject it. Pero sa Pilipinas, no, kung meron nagbebenta ng mahal, ano gagawin ng buyer? May kasamang pula yun. Napakamahal naman ito. So anyway, no, rules governing auction sales. Number one, sales of separate lots by auction are separate sales. The sale is perfected by the fall of the hammer or in any other customary manner. In a traditional auction, no? So merong hammer. Pagka napagpalo ng hammer, the sale is perfected. So kung sino man yung highest bidder, bayad siya. Number three, the seller or his agent may bid in an auction sale, provided such right was reserved and that notice was given that the sale is subject to a right to bid on behalf of the seller, and the right to bid by the seller is not prohibited by law or by stipulation. So klase na ba nangyayari sa auction sale, no? May set price pa to? Pag sa auction sale, merong minimum bid. Okay? Merong minimum bid, tapos kung sinong interesado dun sa sa property na 'yon, tataasan yung bid niya. Tapos yung ibang tao doon, kung gusto niya makuha yung bagay niya, tataasan yung bid niya. So pataasan ng bid to. Alright? Unless wala nang higher bidder pa sa'yo. General rule, ownership of the thing is transferred by delivery. The purchaser acquires a real right or ownership of the thing after delivery. Delivery may be actual or constructive. So we'll be discussing more about constructive delivery maybe in the next PowerPoint. So mapapansin niyo class, no? Merong real right, no? So kung merong real right, merong personal right. Okay? So let's remember our obligate din. Okay? Pag personal right, it's your right against a specific person. Pag real right, it's your right against the world, no? It's your right to hold the thing against the whole world. Yun yung real right. So yung buyer or yung purchaser, magkakaroon lang siya ng real right sa thing kapag na-deliver na sa kanya yung thing. All right? So the purchaser acquires a real right or ownership of the thing after delivery. Okay? Kasi pag hindi pa yan na-deliver sa kanya, ano lang meron sa kanya? Personal right lang. Personal right lang as against the seller. All right? But not against the whole world. Okay? We'll be discussing about that more in the next PowerPoint slides. Exception. When the parties stipulate that despite the delivery, the ownership of the thing shall remain with the seller until the purchaser has fully paid the price. So delivery is still needed to convey the ownership. So parang yung discuss natin earlier. No, na pwede pag-usapan na yung ownership malilipat lang to pag fully paid na yung price. Okay? But as a general rule, ownership is transferred upon delivery. So what are the kinds of promises which are reciprocally demandable? An accepted unilateral promise to sell in which the promisee elects to buy. For example, nag-promise ikaw na ibebenta mo sa akin yung ballpen na hawak mo ngayon. Tapos sabi ko, sige. Parang balik tayo. Sabi mo sa akin, ibebenta mo sa akin yung ballpen mo for 10 pesos. Sabi ko, sige, pupayag ako. Okay? Pag ganyan class, no, it's kahit verbal lang yan, okay lang. Bakit? Kasi it's less than 500 pesos. Okay? It's less than 500 pesos. Hindi naman kailangan in writing yan. So that is enforceable. Okay? So ako, I can demand for the delivery of the ball pen. Ikaw, you can demand for the you can demand for the payment of the of the for the payment of the ball pen, for the payment of 10 pesos. An accepted unilateral promise to buy in which the promisee elects to sell. A bilateral promise to buy and sell reciprocally accepted in which either of the parties chooses to exact fulfillment. Effect of unaccepted unilateral promise or offer. There is no juridical effect or legal bond. So unaccepted offer is called policitation. If S offers or promises to sell to B his cat for 1,000 pesos and B just lets the promise go by without accepting it, neither S nor B is bound by any contract. So kasi nag-offer, let's say nag-offer yung let's say nag-offer yung let's say ako, ino-offer ko na ibenta yung kotse ko with plate number, etc. for 100,000 pesos sa'yo, no? Ino-offer ko sa'yo ngayong araw. Eh wala, di mo ko pinapansin. Okay? Tapos, let's say next week na, lumipas na isang linggo, lumapit ka sa akin. Sabi mo, attorney, ito yung 100,000 pesos, akin na yung kotse mo. Pwede ba ako humindi doon? Yes, class, pwede. Okay? Ito 1 week na lumipas. 1 week na lumipas, tapos hindi mo ako tapos hindi mo ako pinansin nung time na ino-offer ko siya sa'yo. Right? Hindi mo ako pwede pilitin na ibenta sa'yo. Okay? Unless merong option contract. So what is an option? An option contract is a privilege of a person which gives him the right to buy or sell certain merchandise or certain property if he so chooses. There is a need for payment of option money which is separate and distinct from the purchase price in order to have an option contract. So class importante ito. The option money must be separate and distinct from the purchase price. It is only when the option is exercised when a sale may be perfected. Example, if S offers or promises to sell to B his cat for 1,000 pesos and B paid 100 pesos to S for giving him the right to buy the cat if he or she chooses within an agreed period at a fixed price, its acceptance produces consent or meeting of the mind. So class ganito, no? So binibenta, let's use this example here in the slide. All right? Ino-offer ni S yung pusa niya kay B for 1,000 pesos. Eh si B hindi pa makapag-decide, no? So ang ginawa ni B, nagbigay siya ng 100 pesos, no? Nagbigay siya ng 100 pesos sa seller. Sabi, seller, bigyan mo ako ng 1 week para mag-decide. Okay? Pag lumampas yung 1 week, tapos hindi ako makapag-decide, hindi okay lang, sa'yo na yung 100 pesos na yan. Alright? Pero class, pag ganyan, ibig sabihin, yung offer na yan, magsistand yan. Okay? Magsistand yan. The offer stands pag merong option money, pag merong option contract, merong consideration. Kasi class, kung isipin mo, masyadong unfair. Kapag 1 week na lumilipas, tapos yung seller, gusto mo, nakapako siya dun sa pangako niya. That is unfair for the seller. Okay? Ngayon, para mabalanse yun, anong dapat gawin ng buyer? Magbigay ng option money. Okay? Kasi itong option money, pwede yan tanggapin or pwede yan i-deny ng seller. Hindi obliged ang seller na tanggapin ng option money. Pero kung pumayag siya na magkaroon ng option money para bigyan ng time yung buyer na mag-decide, dapat naman i-honor niya yung offer niya. Okay? So that is the purpose of an option contract. So let's talk about risk or loss of deterioration. If the determinate thing is lost before perfection, So class, dapat alam natin yung perfection. No? The seller bears the risk of loss in accordance with the principle that the thing perishes with the owner. No? The principle of res perit nomino, the Latin term. So dito class, no? So yung seller, bago pa niya nabebenta sa'yo, sinasunog yung tindahan niya, who bears the risk of loss? Eh syempre siya. No? Imposible namang ikaw as the buyer. No? Number 2, if the thing is lost at the time of perfection, sa time na magbibigay ka pala ng consent, no? The contract is void or inexistent. It is the same effect when the object is lost before the perfection of the contract. Okay? So class, malinaw yan, no? So the contract is void or inexistent. Kasi kumbaga, walang item na binibigay sa'yo. Wala na. Number 3, and this is important. If the thing is lost after perfection but before its delivery, the risk of loss is borne by the buyer. Okay, by the buyer. This is an exception of res perit nomino. This is because the buyer also enjoys the fruits of the thing after perfection but before delivery. So class, if you remember our example sa oblicon, paano kung meron kang binibili na aso? Hindi pa na-deliver sa'yo. Pero meron na perfection. Okay? Tapos yung aso, nanganak. Sinong entitled dun sa puppy? Is it the seller or the buyer? It is the buyer. Now, in the same way, no? Paano, let's say kung pumunta ka sa sapatusan, tapos meron ng perfection, meron ng perfected sale, pero hindi pa na-deliver yung sapatos sa'yo. Eh biglang nasunog yung shoe store. Who bears the risk of loss? It is the buyer. Okay? If the sale of fungible goods, so dapat alam na natin ang fungible goods. Okay? Example, yung mga bigas, yung mga palay, yung mga nasusukat, yung mga nagagawa per kilo. Okay? Kasi pare-pareho lang yan. Kumbaga, ang 1 kilo ng dinoradong bigas of this kind, kapareho lang ng 1 kilo ng dinoradong bigas of the same kind. Okay? If a sale of fungible goods is sold for a price fixed in relation to weight, number, or measure, they must first be weighed, counted, or measured and delivered in order to transfer the risk of loss to the buyer. However, the vendee will still assume the risk if the vendee incurred a delay in receiving the goods. Okay? So, isabihin class, no? Ano kung bumili ka ng palay? No? Yun nga lang, hindi pa siya nasusupot. Kasi bumili ka, 1 kilo lang, no? Ano bang ginagawa sa 1 kilong palay? Hindi nilalagay sa plastic. Di ba? Paano kung hindi pa nalalagay sa plastic? No? Hindi pa nalalagay sa plastic, hindi pa na-deliver sa'yo. Tapos let's say nasunog. No? Nasunog yung bigasan. So who bears the risk of loss? Pag ganun, it says yung seller pa rin. Alright? Eh paano kapag natimbang na, etc., na-deliver na sa'yo? Paano kapag natimbang na pala? Paano kung natimbang na, tapos nasa seller pa rin? Who bears the risk of loss? Yung buyer. Okay? Pero pag hindi pa natitimbang, let's say nasa malaking container pa, nasa bodega pa, ganyan. Who bears the risk of loss? Meron na perfected sale, no? Nagsabi ka na, nabibili ka na 1 kilo, pero hindi pa na titimbang. Who bears the risk of loss? It is the seller. Pero kung natimbang na plastic na, who bears the risk of loss? The buyer. Okay? Yun ang sinasabi dito sa PowerPoint slide. Number 4, if the thing is lost after delivery to the buyer, but the buyer bears the risk of loss based on the principle of res perit nomino. So class, importante itong number 3. If the thing is lost after perfection but before delivery, the risk of loss is borne by the buyer. Okay? May exception lang sa fungible goods. Kasi ang sinasabi sa fungible goods, pag hindi pa nasusukat, kapag hindi pa natitimbang, the risk is with the seller. Pero pag natimbang na, okay? Pag natimbang na, nasa buyer na ang risk. Sale of goods by description and or sample. The buyer is given a reasonable opportunity of comparing the bulk with the description or the sample. The bulk of the goods means the goods themselves as distinguished from the sample and or description with which they must correspond. For example yan, bigas ulit. No? Kasi bibili ka ng 10 sako ng bigas. Right? Hindi naman isabihin i-inspection mo bawat butil ng bigas. Di ba? It will take you forever. So, ano gagawin? I-check mo lang yung sample. You can do it by getting, you can do it by getting the sample provided by the seller, or you can get it by, parang isang handful lang, parang inspection mo. Hindi mo kailangan inspection in bawat butil ng bigas. O, kasi masasampal ka ng seller dyan because you will be taking forever. Tapos tawad ka pa ng tawad. So, pero the buyer is given a reasonable opportunity of comparing the bulk with the description or the sample. So, parang magka-quality check yung buyer kung tama ba yung binibili niya. Sale by description. Where the seller sells the things as being of a particular kind, the buyer, not knowing whether the seller's representation are true or false, but the buyer relies on them as true. Where the buyer has not seen the article sold and relies on the description given him by the seller. Where the buyer has seen the goods, but the want of identity of the goods delivered do not correspond with the description. So pag ganito class, no? Pag hindi tugma doon sa description, the contract may be rescinded. Alright? The contract may be rescinded if the bulk of the goods do not correspond with the description. Bakit rescinded? Bakit hindi annulled? Hindi siya annulled kasi wala namang vitiation of consent. Okay? Rescinded siya kasi merong panloloko in the sense na ibang bagay yung parang binigay sa kanya. Ibang bagay yung binebenta. Kaya siya rescinded. Okay? Sale by sample. The parties contracted solely with reference to the sample with the understanding that the bulk was like it. It must appear that the exhibition of the sample by the seller was an inducement of the sale or formed the sole basis thereof. The vendor warrants that the things sold and to be delivered by him shall conform with the sample in kind, character, and quality. So ito yung para pinapakita yung sample, no? So dapat yung bulk, no? Dapat kapareho ng sample na yun. Sale by description and sample. When a sale is made both by sample and by description, the goods must satisfy all the warranties appropriate to either kind of sale. The bulk of the goods must correspond with the sample and the description both. Pareho. Article 1482. Whenever earnest money is given in the contract of sale, it shall be considered as part of the price and as proof of the perfection of the contract. Now, this is interesting class, no? We have to compare earnest money with option money. Ano ba yung pagkakaiba ng dalawa? So, una muna. Ano ba ang sabihin ng earnest money? Money given by the buyer to the seller to bind the bargain. Okay? Ano option money? Ang option money, parang binibigyan mo yung seller ng option money para bigyan yung buyer ng pagkakataon mag-decide kung bibili niya or hindi. So, ang earnest money, it's actually a partial payment of the purchase price and it is considered a proof of the perfection of the contract. So, ang earnest money, meron na perfection, meron na perfected sale. Ang option money, wala pang perfected sale. So, an earnest money is advanced payment. It must be deducted from the total price. Option money may become earnest money if the parties agree. So, difference between earnest money and option money. Earnest money, part of the purchase price. Option money, money given as distinct consideration for the option contract. So yung option money, hiwalay ito dun sa presyo ng thing. So earnest money, it is given when there is already a perfected sale. Pag option money, there is no perfected sale yet. Earnest money, when earnest money is given, the buyer is bound to pay the balance. In option money, the person who gave the option money is not required to buy because the buyer may choose whether to buy or not. No? Pag option money. So a form of a contract of sale, general rule, it may be in any form. It can be written or oral. Exception, if it is covered by the statute of frauds, it must be in writing. Otherwise, the contract of sale is unenforceable. Again, class, no, it's not void, but it is unenforceable. So what are the contracts of sale under statute of frauds? Number one, sale of personal property at a price not less than 500 pesos. Okay? So kung 500 pesos and above, dapat, sorry, dapat it should be in writing. Okay? For it to be enforceable. Letter B, sale of real property or an interest therein regardless of the price. Pero class, no, sa totoo lang, meron pa bang real property na ang presyo is less than 500 pesos? Wala na. But the thing is, itong civil code, ginawa to 1950. During that time, ang 500 pesos, ang dami mo nang mabibili doon. Sa ngayon ba, sa 500 pesos, anong abutin niya? Marami pa rin naman. But definitely not real property. Okay? Letter C. Sale of property not to be performed within a year from the date thereof, regardless of the nature of the property and the price. So ito yung mga contracts of sale under statute of frauds. Sale of real property or interest therein. So class, ito especially for BSA students, remember this, all right? The sale of a parcel of land or interest therein made through an agent is void unless the agent's authority is in writing. Okay? Again, class, no? The sale of a parcel of land or interest therein made through an agent is void unless the agent's authority is in writing. So dapat in writing, ha? Dapat in writing yung kapag agent yung magbebenta ng lupa. Alright? The authority must be in writing. Pwede ba magbenta, class, no? Pwede ba magbenta ng kotse through an agent? Yes, pwede. Does it have to be in writing? Not really. No? But syempre, in the practical matters, ang LTO, humingi ng SPA, parang ganyan. Or the special power of attorney. Okay? The sale must be in a public instrument. Ibig sabihin ng public instrument, it has to be notarized and registered before the registry of deeds where the land is located. Nasa mga registry of deeds ng Lucena. Nasa school nyo, nasa DLL. If it is in a private instrument only, it is only valid between the parties and not as against third persons. So ito ang nature ng land transactions class. Kung mapapansin nyo, pag lupa pinag-uusapan, ang dami nagpapatayan, ang dami nag-aaway, kahit mga pamilya. No? Pag lupa pinag-uusapan, iba. Alright? That's why for the peace of mind of everybody, no? Kung may nagbebenta sa inyo ng property or basta mayroong property na involved, i-check niyo yung title. Okay? I-check niyo yung title. Kung yung nagbebenta sa inyo, talagang siya yung nasa pangalan ng title, no? Kasi kung hindi, ang hirap yung malipat sa iyo. Okay? Kung ahente siya, make sure na meron siyang SPA o special power of attorney na notaryado. Okay? Statute of frauds, it is applicable only to executory contracts. Executory contracts are those where there is no performance, such as delivery or payment yet by either party. So sa executory contract, Let's say, sabi mo, pare, benta kasi yung kotse ko, 500,000 pesos. Tapos sabi mo, sige. Tapos the next day, hindi nakikibuan yung mga parties. Itong isa, hindi pa na binibigay yung kotse, yung isa, hindi pa nagbabayad. So pag ganyan class, no, the contract is unenforceable. Alright? Neither party, kahit sino sa kanila, hindi pwede pumunta sa korte para kasuhan yung isa. No? Kasi verbal lang yung agreement hindi nakasulat Okay? Pero paano kung merong partial performance? Partial performance is a reliable evidence of the intention of the parties of the existence of the contract. No? Kasi in the first place, bakit meron statute of frauds? No? Bakit ba pag more than 500 pesos, tapos hindi in writing yung sale ng personal property, bakit siya unenforceable? Plus, kasi ginagawa yan para matigil ang panloloko. It's to prevent fraud, actually. Kasi paano kung may lumapit sa'yo? Sabi, uy, bayaran mo yung binili mong kotse. Wala kang binibiling kotse. No? O kaya sinabi sa'yo, o yung kotse, sabi mo, bibilin mo. O ito na. Tapos sinisingil ka. Ganyan. O para to prevent fraud, to prevent injustice, wag executory pa lang yung contract. No? It's unenforceable. Hindi mo yung pwede dalhin sa korte. Pero kung meron ng partial performance, let's say binayaran na yung kotse, o kaya deliver na yung kotse, dapat, pwede na kasuhan yun. Let's say dun sa example, nagbayad ka ng 500,000 pesos, tapos yung kotse ayaw i-deliver sa'yo, pwede mo na siya kasuhan doon. Kahit wala kayong written contract. Okay? Paano kung paano kung deliver niya yung kotse tapos ayaw na mabayaran? Pwedeng kasuhan kasi hindi na siya executory. Meron ng partial performance. Pag meron ng partial performance, pwede na kasuhan. Okay? A contrary rule will result to injustice and unfairness. So, malapit na tayo matapos, no? What are the remedies of the vendor sa the seller? No? What are the remedies of the seller in sale of personal property payable in installments? So, class, importante ito. Alright? So, naka-highlight dito personal property. Personal property. Number 1, elect fulfillment upon the vendee's failure to pay. So kung isang installment hindi pa nababayaran, let's say, ano bang magandang example nito? Personal property payable in installments. Motor. O kaya kotse, no? Ang motor at saka kotse, these are personal properties. Okay? Kapag nakabis ka ng isang installment, pwede na ba agad hilahin ang motor? Hindi pa pwede. Pwede na ba agad foreclose yan? Hindi pa pwede. Okay? Number 1, elect fulfillment upon the vendee's failure to pay. So kakasuhan. Kakasuhan para ma-recover yung unpaid amount. Number 2, cancel the sale. If the vendee shall have failed to pay 2 or more installments. So importante to class, no? 2 or more installments. Pag isa pa lang, hindi pa pwede i-cancel yung sale. Pero pag 2 or more na, pwede na. Number 3, foreclose the chattel mortgage if one has been constituted, if the vendee shall have failed to pay 2 or more installments. So class ito. So kasi bumili ka ng motor, no? Syempre anong collateral mo? Yung motor din. Ganyan, no? Kapag hindi ka nakabayad ng 2 or more installments, pwede yan i-foreclose pwede i-foreclose ng seller. Alright? Pwede yan i-foreclose ng seller. Pag foreclose mo ng seller, ano bang isabihin doon? Siya na may-ari? Hindi. No? If for public auction yan, yung motor na yan. Tapos pupunta yan sa highest bidder. Okay? So ito ang remedies ng vendor sa sale ng personal property. Okay? These remedies are alternative and are not to be exercised cumulatively or successively. Kung ikaw yung seller na sa pinili mo, exact fulfillment, yun lang ang pwede. Pag pinili mo cancel, yun lang ang pwede. Pinili mo foreclosure, yun lang ang pwede. Okay? The election of one is a waiver of the right to resort to the others. So what is the right of the vendor to recover the unpaid balance of the purchase price? Sa remedy na specific performance, if specific performance is chosen, the buyer is still liable for the unpaid balance if the proceeds of the execution sale still falls below the unpaid balance. Okay? Sa remedy na cancellation, the buyer can demand only the return of payments already made unless there is a stipulation about forfeiture. In the remedy of foreclosure, there shall be no further action for the recovery of any unpaid balance of the price. And the agreement to the contrary is void. So, importante to class, no? Pag foreclose na yung pag foreclose yung motor mo, tapos meron pang, let's say, kulang, no? Let's say, malaki yung utang mo dun sa seller. Hindi ka na pwede singilin ng seller dun sa mga hindi pa bayad na utang. Once nahila na yung personal property, yung motor mo, that's it. Wala ka na kailangan bayaran. Any agreement to the contrary is void. Ang tawag din dito, recto law. Recto law. That's R-E-C-T-O, law. L-A-W. Recto law. Alright? So recovery of deficiency after foreclosure is prohibited. The mortgagee is limited to the proceeds of the auction sale of the property included in the mortgage. To prevent the mortgagee from buying the mortgage property at foreclosure sale for a low price and then bringing suit against the mortgagor for a deficiency judgment. So class, again, we're talking only about foreclosure of chattel mortgage. E paano kapag ang sinangla, ito ha, paano kapag ang sinangla, for example, bumili ka ng motor, installment. No? Eh, ang ginawa mo para makabayad ka ng installment, sinangla mo yung truck mo. No? Ngayon, hindi ka makabayad ng installment. So yung truck mo, foreclose. Ibig sabihin ba, let's say ang nakuha ng truck, maliit lang, may utang ka pa rin. Pwede ka pa rin ba singilin dun sa utang mo? The answer is yes, pwede. Okay? Recto law does not apply. Bakit? Recto law only applies kapag kung ano yung mismong binili mo, yun yung naka-chattel mortgage. Okay? Let's say yung motor mo, yun yung naka-chattel mortgage. Doon ka lang hindi na pwede singilin. Pero pag ang sinangla mo ibang bagay, pwede ka singilin doon pag kulang yung auction sale. Ibang trato nito class sa real estate mortgage. Sa real estate mortgage, kapag sinangla mo yung bahay, let's say bumili ka ng condo or let's say bumili ka ng bahay, no? Tapos naka real estate mortgage yung yung bahay mo. Tapos na foreclose yung bahay mo. Tapos kulang yung bayad sa bahay mo dun sa utang mo. Are you still liable to pay the balance? Yes, you are still liable. Okay? A stipulation authorizing forfeiture of installments or rents paid. The parties may stipulate that the installments or rents paid are not to be returned. It is valid insofar as they are not unconscionable under the circumstances. Sabihin, basta hindi siya sobrang unfair, no? If to the court's appreciation, it is unconscionable, babaguhin ng court yan, no? The courts have the power to order the return of a portion of the total amount paid in installments. Kapag masyadong unfair naman for the buyer, okay, the court has that power. Only if unconscionable under the circumstances. So expenses for execution and registration, the parties can stipulate who shall pay, but the vendor has the duty to pay for the expenses for the execution of the sale and the registration of the sale. If in the absence of agreement as to who shall pay, the vendor shall pay for the expenses. The buyer shall shoulder the payment of all expenses subsequent to the transfer of the title. So class, we end here. This is the end of chapter 1. So we'll be seeing each other in the next chapter. So keep safe, take care, and God bless.